Good morning, everybody. I told you several times in my previous videos that I have started this web series to bring to the notice of the citizens of India various articles of the Constitution which are seminal for democracy and development and which were misunderstood, misinterpreted, and misused, as a result of which we are suffering political uncertainty, political instability, horse trading, social strife, and economic backwardness. I have started this venture with fond hope that the constitutional knowledge which I am going to disseminate would bring a social, political, economic change in India for the good of the country. I request all of you to please subscribe, share, and comment on my videos so that this constitutional knowledge will reach to as many people as possible. Till yesterday, we have completed up to Article 123, which was related to power of the President of India to issue ordinances during the recess of the Parliament. Today, we will discuss Article 124. Article 124 mainly relates to appointment of Supreme Court judges and their removal. Article 124(1) says that there shall be a Supreme Court for India and there shall be a Chief Justice and 7 other judges. And the number of judges may be increased by the Parliament. Article 124(2) says that the Supreme Court judges shall be appointed by the President of India under warrant, under his sign and seal, subject to the prescribed qualifications. The qualifications are that he must be a citizen of India, he must have completed service as a High Court judge for at least 5 years, or he must have practiced before a High Court or a Supreme Court for 10 years. That is not a big thing. We can find several people with these qualifications, but the ultimate test is that if he is an eminent jurist in the opinion of the President of India. So it is the President of India who appoints Supreme Court judges according to Indian Constitution. In the year 1999, the Association of Supreme Court Advocates on Record filed a public interest litigation before the Honorable Supreme Court, pleading that the appointment, etc., of Supreme Court judges should not be in the hands of the President. If it is in the hands of the President, they argued that the independence of judiciary cannot be achieved. Judiciary has to be independent. Honorable Court, endorsing the view of the Association of Advocates on Record of Supreme Court, has formed a collegium system whereby a Supreme Court Chief Justice and 4 other judges will form a collegium and they will recommend the names of persons to be appointed as Supreme Court judges, and the President has to appoint them as judges. So in 2013 or so, Parliament has come to senses that the Constitution was deviated. They introduced 99th Constitutional Amendment to save face, that the appointment of judges shall not be recommended by the collegium as decided by the Supreme Court of India. Thus, there is a conflict between the Supreme Court and the Parliament. Through 99th Constitutional Amendment, Article 124A, B and C were introduced to the effect that there shall be a Judicial Appointments Commission consisting of certain members, the Prime Minister, the Law Minister, and two other eminent persons who could be from scheduled castes and scheduled tribes, the Chief Justice of India, and the opposition party leader, etc. Again, the Association of Advocates on Record of Supreme Court filed a petition in the Supreme Court, and the Supreme Court was pleased to strike down 99th Constitutional Amendment. In view of the judgment, even today, the collegium system is continuing. Important point for discussion is that should the judiciary be independent of the Parliament and the President, and what is meant by independence of judiciary, and if the judiciary is appointed by the President of India, whether it affects the independence of judiciary. First of all, I inform you that the word independence of judiciary is not used in the Constitution. It only said that the President of India appoints judges with the specified qualifications if they are eminent jurists in his opinion. There is an argument that justice will be politicized. On one hand, we say the President of India is apolitical, is the constitutional head, is the head of the state, and on the other hand, we are saying if the authority to appoint judges is in his hands, the independence of judiciary is compromised. The Constitution compiled by Dr. B.R. Ambedkar has provided a unique independence to judiciary, which of course is not understood by Indian polity, press and judiciary and the intelligentsia of this country. The freedom is that they are appointed by none other than the President of India, who is representative of 140 crore people of this country, whose actions are subject to scrutiny by the voters of this country. If he misbehaves, the Parliament can impeach him under Article 61, or the people may punish him in the ensuing general elections by not voting for his political party. So the appointment is made by none other than the President of India under warrant, sign and seal, and he has no power to remove them. How independence is compromised? He can appoint, but he cannot remove them. Their service is not in his hands. To remove a judge, the procedure is contained in Article 124, Clause 4, that at least 50% of the total membership of both houses of the Parliament should separately pass a resolution, and there should be 2/3 of the members attending and voting, and the votes endorsing impeachment of a judge should be more than 50% of the membership of that house. So it is a very tough process to remove a judge. He is appointed by the President, and the President has no power to remove him, and the procedure prescribed to remove a judge is a very difficult one. As such, the independence of judiciary is perfectly protected. Of course, the Honorable Court, in delivering this judgment regarding collegium system, has taken support from Article 50 of the Constitution, which is part of directive principles of state policy. We know directive principles of state policy do not have legal force. They are advisory in nature to the government. Article 50 only says that the judiciary may be separated from the executive in public service. Judiciary consists of Supreme Court, High Court, and down the line up to Magistrates Court. And executive in public service means the employees of the state and the center. It was only an advice to separate judiciary from the executive in public service. I told you there was sufficient independence, more than that of anybody in the country, more than the ministers. Supposing the term of office of ministers under Article 75 shall be during the pleasure of the President, an unquestionable authority to remove them. We have introduced an element of no confidence motion to remove a Prime Minister, which again is a fallacy. Such kind of practice is contained in Pakistan Constitution Article 95 but not under any provisions of Indian Constitution. The terms of office of state ministers shall be during the pleasure of the governor under Article 164. Such a condition was not imposed on the judiciary. So, their jobs are secure, they are sufficiently independent. And I will ask you a question. The collegium system has come into existence from 1999. Can we say that the judgments delivered by the Honorable Supreme Court until 1999 were not independently delivered? Do they not serve as precedents? So it is not proper to say that the judiciary was not independent until 1999 or until formation of the collegium system. In fact, it is only after formation of collegium system there was so much of uproar, criticism against the judiciary on various reasons, various grounds. So the Constitution intended that the President of India should appoint judges, and moreover, the President appoints certain judges. He cannot remove them. Now the Supreme Court judges may be around 35 or 40. Only a small portion of them might have been appointed by the President during his tenure. And there is a multi-layer appellate system in the Supreme Court. Issues may be decided by a single judge, or that may be referred to a two-judge bench or three-judge bench or five-member forum or 7 judges or 15 judges. We cannot say that all the judges could have been appointed by the President of India. Supposing we say the President of India may be biased, may be political, it is as good as saying that I am more loyal than the king. He is the king, he is trusted by 140 crore people who are we to question. And judges to be independent, they should be saints. They should not have families, and then they will not have personal interests. They should be free from corruption. They should be free from fear or favor. They should not have personal interests. The best thing is that they should be saints, sannyasis, so that they will not have any personal interest. If we sacrifice the wisdom of 775 parliament members and depend on the wisdom or legal knowledge of 3 judges, I don't think the country would go for long like this. After all, a democracy, the will of the public should prevail. So in my opinion, we should restore the powers of the President to appoint judges, and the Parliament and President together should be able to impeach the judges. Otherwise, we will be violating the Constitution totally. If the Honorable Court is entitled or authorized to ignore Article 124 or any one article of the Constitution, it amounts to saying that the Honorable Court can ignore any provisions of the Constitution or the total Constitution. As such, it is not advisable on the part of the judiciary or anybody to transgress the Constitution. The judiciary is already uniquely independent under the Constitution compiled by Dr. B.R. Ambedkar. Now, through collegium system, instead of freedom or instead of independence, the judiciary gained dominance over the legislatures and the executive as well. In a democracy, there should be separation of powers between the legislatures, the executive, and the judiciary. One should not meddle with the functions of the other organization. If they do that, there will be a clogging, there will be conflict, and as a result, there will be injustice to the people and to the country. Thank you. Thank you for watching my video. I continue to bring to your notice all the constitutional conflicting issues with fond hope that they will help this country. Thank you. Thank you for watching my video. Thank you.